It's not unusual for a disability carrier to demand that the policyholder prove that there's an objective basis for the restrictions and limitations assigned by their physician and their inability to perform any occupation. You have to show that connection. Well, one way to potentially do that is a functional capacity evaluation. That will document the level of functionality. In other words, how long can you sit, stand, stoop, walk, or bend? But you have to combine that with the opinion of a vocational expert as part of a 1-2 punch to overcome a carrier denial. However, an unfavorable FCE can be the kiss of death. I think it's important that you consult with an experienced ERISA disability attorney before you have a functional capacity evaluation. And as a lawyer who handles cases across the United States, I read cases and learn lessons, and one of them is found in Lord versus American General Life. Now, this plan provided for the payment of benefits after 36 months only if the policyholder was unable to work in any gainful occupation, even on a part-time basis. Pretty restrictive. Now, Lord had not one but two unfavorable FCEs. American General Life denied the claim, and Lord appealed. What did the court do? Well, the court said that the denial was not arbitrary and capricious, and agreed with the denial, particularly since there were two functional capacity evaluations that found Lord could either work in a light duty capacity, and then the second one in a sedentary capacity. What was worse was her medical records didn't support her disability from any occupation, and as a result, the clinical nurse manager and the VE providers, vocational evaluator providers, for American General Life concluded she could do sedentary work and light work. The peer review provider found that she had no other workplace restrictions and limitations in view of her medical condition and her medication use. So the two unfavorable FCE providers were a 1-2 knockout punch for Lord, and when you combine that with the unfavorable medical records, there's no doubt that the judge was going to find that the denial was correct. So what are the lessons learned? Well, I think the lessons that are learned are: number one, you need the assistance of an experienced ERISA disability attorney to find the right FCE provider, not one that is basically in bed with or has significant relationships with insurance companies, because they're going to give a carrier what they want regardless of who pays it. That's just their mindset. Number two, you need to make sure that your medical records support your claim. And number three, if you're going to have a functional capacity evaluation, you want your treating physician, if possible, to endorse the results of the FCE. Because, as I said, you've got to show the objective evidence of the restrictions and limitations, and that will help you prove that causal relationship between your inability to do your own or any occupation. And of course, the next tip is you need to have an experienced vocational rehabilitation counselor who understands the LTD disability policy language so that they can craft a favorable report that basically connects your restrictions and limitations to your inability to do the material and substantial duties of your own or any occupation. You need that opinion because a vocational expert is just that. They're an expert in the world of work. If you have any questions about your rights to your long-term disability benefits, or undergoing an FCE, or even appealing a wrongful denial, call me at 727-894-3188 for a complimentary consultation. I look forward to helping you get the disability benefits you deserve, regardless of where you live in the United States.